I'm going to introduce you to the Honorable Donald G.H. Bowman. And of course, Chief Justice Bowman, as he was then called, presided over a case that Jordan referred to called Northwest Hydraulics versus Her Majesty the Queen. And in this particular case, there was a group of individuals from a university in Western Canada who formed a company called Northwest Hydraulics, who was attempting to determine the best method of harnessing power from water, energy from water, dealing with soil sedimentation, erosion, various different issues came up. And of course, this area of science was well established, perhaps thousands of years. They had dams and dikes in Egypt. Having said that, the case that is the best known case and has been heard by every, has been considered and cited in every case that's ever been heard by the Tax Court of Canada and the Federal Court of Appeal, is a subject of this interview. Jeremy, I'd like to ask you to display the video, and as we do, there are three primary reasons that we find CRA wrongly denying claims for SR&ED. One is documentation. Jeremy, if you could please play the first slide. Justice Bowman, I wanted to ask you about the issue of contemporaneous documentation. Do you believe that at the audit level, do you believe that contemporaneous documentation should be the basis for determining eligibility, or do you believe that the requirement for documentation should only be evidentiary only? In other words, should be purely to support that the activity took place?
It should be primarily evidentiary, but I'm not saying that it should, that a claim for scientific research tax credit should be excluded if there is no contemporary documentation. There should be. Depends on whether or not the researcher is believed.
You are aware that, and I know that you are, the 5 questions that CRA arms RTAs with, they've taken your 5 questions from Northwest Hydraulics and they've made a slight revision to one of them to say that there's a record of the hypothesis kept as the work takes place, which really has put RTAs in a position where, you know, they're now, at least in many cases, basing the decision on whether the work is eligible or not on the documentation, rather than looking at the documentation as being evidentiary only.
Well,
very good, Jeremy.
I would say that the document.
Very good, thank you. I'd just like to invite our expert panel to comment. And of course, we have several litigators with our panel today. And in arguing matters before the Tax Court of Canada, or whether it be dealing with the CRA on matters of tax dispute, the issue of contemporaneous documentation is not a new one. By definition, contemporaneous documentation is documents that are created at the time activity takes place. And whether it happens to be a claim for scientific research or a denial of a deduction for a number of different reasons or any other tax matter, it's something that often is contentious subject. So we've heard what Chief Justice Bowman had to say. He said that documentation should be evidentiary, although it's useful. Perhaps I'd like to invite Brian Carr to comment on your experience involving the importance of documentation and when it's not necessarily required in your view.
Well, I think when you're dealing with the audit division, contemporary documentation is always important, in my view. It is often very hard for the CRA to get to the CRA to look at anything else except documentation that was created at the time. At the audit stage, you certainly don't have the ability to start presenting witnesses to them they'll listen to. The CRA has a basis belief that documentation evidence is the only evidence that's worthwhile. So if you don't have contemporary documentation, you're going to have a very, very tough time with the audit group. With the court, you'll get a little more leniency. There are judges up there. They understand that evidence can consist of documentary evidence and also oral evidence and what people say. So you're not really stuck with just the evidentiary documentation. At the same time, you're in an area where if you're doing scientific research, one would think that you're going to have some notes, some preparation showing what the results of experiences are. My own background is in physics and chemistry at the undergraduate level, so I sort of sit there and say, well, you know, you did an experiment, you had to write down the results somehow. You don't expect people, scientists, not to have the documentation. So it's going to be an uphill fight if you don't have contemporary documentation. I always say, just as a general litigation matter, I tell planners this, as well as litigators, you're doing a transaction. There's perhaps a weak point in a transaction. How are you going to justify, how are you going to prove to a court at some point in the future that you satisfy a particular section? What evidence are you going to have? Therefore, when you're doing the transaction, you should be preparing the evidence as best you can, whether that's memorandum to file or some other contemporary documentation that you can pull out at the time that you get challenged by the CRA and you find yourself in court. So same answer goes to the scientific research and ED area. Prepare your documentation at the time and be prepared to present it to the CRA and the court when the time comes.
Yeah, I think it's needless to say that documentation is always important. It's always the very best method. The problem is that it isn't always the case, that companies have kept the kind of document that CRA may like, as an example. And at times it becomes a moving target. And the other issue often is that when claims are being rejected on account of not having sufficient documentation, it isn't always a question of whether or not the activity took place. It's a question of whether or not there was, say, a technological uncertainty, or whether or not there was a genuine advancement. And as Brian mentioned, I think it's reasonable that when you're doing experiments, it should be expected that a clinician or a technician or anyone who's involved in that kind of work would do things in a disciplined way. So by no means are we suggesting that documentation shouldn't be kept, but the standard for documentation is one that's difficult to determine. Perhaps Michael Meller, I would ask you as a civil litigator about the issue involving contemporaneous documents and your view of perhaps recreation of documents that are intended as a summary of past events in lieu of contemporaneous documents, and what your experience might be.
Yeah, contemporaneous is what's important. If you recreated it, the question is that done by a lawyer to make it easier for a judge? And if so, does the other side agree to have it put forward as evidence, and or at least of what the argument's going to be? So it's what happened at the time is the best evidence, and how it was recorded. That's what's important.
Very good, very good. And Mayor Mackey, I'd like to just invite you. I'm thinking about 116976 Canada. And of course, I believe it was Justice Somerville who stated that it is possible to adduce eligibility based upon oral testimony, but one puts themselves, as you put it, in a precarious position by relying on oral evidence. I'm just curious, Michael, Mayor, what your view would be as far as documentation and the level of documentation that should be for any tax matter whatsoever.
So in terms of SR&ED, if we're talking about SR&ED, you definitely need, if you're doing experimentation, it's prudent to, like Brian Carr stated, that it should be somewhere. Now, if you don't have it, nowhere in the act for SR&ED does it state that you have to have documentation. You could, if you don't have it in tax court, like Brian Carr stated, they'll be more lenient, and you could draw that in testimony when you call your expert or your client up to the stand. You could draw what they did in testimony. Moreover, in electronic health records, Madam Justice did a good job at explaining this issue. Let me just read what she said. She said, while it's always preferable that an appellant maintains contemporaneous documents to support its systematic investigation, the Act contains no legislative requirement to file those documents in order to qualify for deductions of expenditures. This is not to say that taxpayers should ignore detailed record keeping. Such documentary evidence is always to be preferred in each case. Now, documentation isn't always your test results. Sometimes we've had cases where a robotics client was trying to create a camera for reflection. It was very unique what they were doing. So what we had was 1,500 pictures where if you see two pictures together, it looked like the same pictures. But when you put all the pictures out in front in this diagram, you see the different iterations they were going through. So pictures, it wasn't the testing, but the pictures proved the testing. So sometimes it comes in different shapes.
Yeah, I think at the end of the day, the consensus is, although documentation is important, it isn't necessarily the determination for eligibility. It ought to be evidentiary, but without that, it's very difficult to adduce credibility. Jeremy, I'd like to ask you to continue the video, please.
Documentation is the strongest evidence that you have in many cases. So try to have it, but I'm not saying that it's essential that I would reject scientific research claims just because there is no documentation. Depends on whether you believe the taxpayer.
Chief Justice Bowman, CRA has taken the position that trial and error is not eligible for SR&ED. Is this semantics, or what do you think about this position?
Well, I think that's baloney.
Please.
I don't know.
I'd like to turn back to the expert panelists for a moment. You heard right from the horse's mouth, not that I would call Chief Justice Bowman a horse, but with all due respect, the question was asked, is trial and error eligible for SR&ED? I can remember in the case of Joel Theatrical, I don't recall the judge, but the comment was he doesn't recall whether or not that there was any cases that specifically stated it wasn't, but he could have seen how it was. I was thinking, anyway, without further ado, I'd like to call upon the expert panel to talk a little bit about this concept of trial and error. Before I do, I would like to share CRA's view of what trial and error is. And in effect, they tend to maintain that trial and error means that you're doing something haphazardly. You're doing something without the guidance of a hypothesis. You have not presupposed what a result would be and worked toward the end, which we can understand. So I guess the question is it semantical or is there substance? Is there any reason? And I think part of the problem is that scientists and engineers often use the term trial and error to describe what others might refer to as experimental development or research that would involve experimentation that would include a hypothesis. Just curious, your view on this expert panel.
Well, I guess it is a bit of semantics as to what you mean by trial and error. If you're just haphazardly playing around in a lab, throwing this component in with that component and hoping for something, well, maybe that's not really scientific research. I think of trial and error as a scientist that you have a concept of where you want to go to, and you're trying to prove that. And sometimes you get there and sometimes you don't. And sometimes you come up with unexpected results which are very favorable. I'm thinking of the sticky notes. That person was starting off trying to develop a glue, and he found out that the glue didn't work. But he developed something far more valuable than the fact that glue had worked. Viagra is another example of a drug they were trying to develop as a heart. My understanding is a heart drug. Found that it didn't work, but it had very interesting side effects. So, I mean, if all you're doing is throwing things around in a lab again, that's probably not scientific research. But scientific research is really a trial and error. You start off with some idea of where you want to get to, and you try to prove that you can get there, or you find out you can't. And that's really, sometimes you get a lot of times when what you thought was the what you thought was going to be the result isn't in fact the result at all.
I think that in general, throwing darts blindfolded is not SR&ED. I mean, the apple falling on Newton's head, well, it just came to him. How is that SR&ED? I don't think that the suggestion is that it is, but oftentimes the problem is companies who are performing what they believe to be trial and error could well be eligible work. Perhaps Mayor Mackey, I'd like to ask you to comment on the notion of trial and error in your experience.
So I think one good example is if I have a piece of wood and I'm drilling into the wood to see which screw, the size of the screw best fits, and I keep trying different screws to see which one goes into the wood the best, that to me would be trial and error. Versus if I have an idea, what Brian Carr alluded to, my hypothesis, following, if you see the work, the systematic investigation going towards your original idea of your hypothesis, and you're trying to find answers to your hypothesis, that would be more of a systematic investigation.
I would suggest the scientific method is one that embodies a hypothesis. And if in doubt, it would be always prudent to consider whether there was a hypothesis that guided the work that was intended to either modify or confirm a hypothesis. Part of the question, I think, that the issue that relates to this is that oftentimes when claims are being adjudicated by the CRA, they present 5 questions. And at times we've seen it presented as the 5 questions in Northwest Hydraulics, as stated, presided by Chief Justice Bowman, as he was then called. Well, question 5 has been changed in CRA's guidance documents. It states, was there a record of the hypothesis kept as the work took place, versus was there a hypothesis? It really relates back to this question of contemporaneous documentation, dealing with the quantity of documentation and the granularity of documentation. So we see there's a connection between the 2 issues. Jeremy, if you continue the video, please.
Believe it at all. I think that trial and error is one aspect of the type of research that goes into scientific research.
I think what they're attempting to say, and of course, I think what CRA has done is they've taken the term trial and error and they've created their own rendition, their own definition.
I don't have any doubt, for example, that Thomas Edison engaged in a lot of trial and error.
Undoubtedly. Good analogy. I would suggest that what they're really saying is there's no hypothesis that guided the work. But the term trial and error, and of course in Joel Theatrical, Justice Somerville had mentioned the same subject and said that he didn't know about any jurisprudence that stated clearly that trial and error wasn't eligible. So again, I think...
No, I agree with that, yeah.
Would you say there should be more training in this area for CRA officials?
They shouldn't need training, for goodness sake. They should be able to reach that conclusion on their own.
Well, how about that? How about that? Listen, I mean, CRA does a very good job at administering the SR&ED program. Certain things are logical, and oftentimes individuals who are purely academics are involved in making determinations on things. And always I recall Chief Justice Bowman's words that things often, an uncertainty is in the mind of the performer, and it may not be obvious to another person. Who is it who could make a determination that someone didn't have a hypothesis? I think as adjudicators, whether it be an auditor or whether it be a judge in the Tax Court of Canada or the Federal Court of Appeal, I think one of the questions always has to be is the basis for eligibility based on this whole question rooted on the basis that there is a hypothesis that guides the work. Jeremy, I'd like you to continue, please.
Which includes incremental improvements, was there to fill a gap, or what was perceived as a gap in the legislation. In other words, the CRA was, I think, erroneously taking the position that if there was something already invented, but they were improving on it, that was not experimental scientific development. And I think in the definition that I had, I used the word infinitesimal improvements.
Yes, you did.
And I think that what I meant was to comment on incremental improvements there too. In other words, it didn't have to be a brand new product. It could just be an improved one.
The concept of novelty is an interesting question, and it's one that you'll very seldom ever connect to SR&ED. Whether or not a product has to be brand new is one question, but I think a more important question is how much knowledge do we have to gain to be eligible? Brian, perhaps you could comment on your view of the quantum of knowledge one would have to gain in order to be able to take a position they've indeed advanced technology.
I think that depends upon, obviously very factual dependency, but you have to show, I suppose, that there is some element of research that, for example, maybe you have a camera that can take 30 pictures a minute and you move it to 60 pictures a minute. What enabled you to do that? Did you have to discover something mechanically that allowed you to do that? Or was it just adding a bigger roll or something? So I think there has to be some small scientific change at least that allows you to produce a better widget, but it doesn't have to be huge. And something that some work that gets you to that result will be scientific research and development.
Very good. And Mayor, your comment on the use of the term that Chief Justice Bowman, as he was then called, used to describe the quantum of knowledge.
I think in Northwest Hydraulic, he said infinitesimal knowledge. What was, I think, 0. I don't know the number, is very small. Knowledge is advancement in knowledge. And just to note too, a failure is considered an advancement in knowledge. So sometimes you'll have different iterations and you'll have small incremental advancements or small failures, but you haven't resolved the whole uncertainty. So if you failed at a project, that's considered advancement too.
Yeah. What about the fact that there's a body of knowledge that exists and we're adding to it? The term incremental, one would have thought would have been enough, that existed in order to describe that something that's incremental is added to something which already exists. So I believe that what Justice Bowman had done is he had actually defined that the amount of advancement in knowledge must only be slight. And I think that's our takeaway. Jeremy, the next part, please.
Definitely. I think the incremental implies that there be an addition or a minor improvement even. I can't imagine what known techniques would have been used by Thomas Edison when he invented the light bulb. And yet, no one would question that was a breakthrough experimental development. Well, routine engineering, standing by itself without benefit of a statutory definition, is it's pretty routine. It's pretty there's nothing unusual about it. That's why that people disagree over it. I think it's high time that they looked at the definition of routine engineering as including aiming at least a result that is not predictable.
All right, so let's stop for a moment, because one of the issues involving routine engineering is where things are not reasonably predictable. And this is in Northwest Hydraulics when the question was asked rhetorically by Chief Justice Bowman, what is routine engineering? And he said briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in the field. Previously, it mentions the concept of reasonably predictable, whether a problem could be resolved where the result was reasonably predictable. Well, what does that all really mean? All too often, the government is denying claims for scientific research on the basis that the work is classified or trivialized to be routine engineering. And of course, this is an area where there's a lack of understanding. And according to Chief Justice Bowman in his decision, he said, no other term creates more controversy amongst the experts than the use of the word routine engineering. And of course, he said that briefly it describes three things, these techniques, procedures, and data. And we'll hear what Chief Justice Bowman has to say about those three things in a moment. If one of those things are missing, could it still be routine engineering? Jeremy, please.
You've went on, this is the second part of your explanation about routine engineering, and you've described it this way. Briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in his field.
Yeah.
Seems to me that the underlying meaning of your decision would have required a great deal of thought in coming up with that.
I don't remember whether I did any thinking or not, but I can assure you, yes, I did. And remember that routine, I meant, was to intended to include techniques, procedures, and data. In other words, methods and information.
Wasn't Jeremy?
There you go.
Okay, so we're talking here, Chief Justice Bowman was just about to refer to routine engineering. And the fact is that we see routine engineering as being akin to a three-legged stool. It may be that your company, or if you're a lawyer or an accountant, your client, had resolved the problem using known techniques. It could be the procedures were known, but the data is the third part. The definition for routine engineering is techniques, procedures, and data. What is data? Data is knowledge. Data is information. And it may well be that the techniques and the procedures were known, but what about the information? What about the data? Was it known? And in the event that you were to consider the work that was undertaken, was there information that was learned? Well, that would imply that there was information that was missing, that was needed in order to accomplish the objectives. If we're able to finish the video, go ahead, Jeremy.
What's interesting is when we see a decision coming down from CRA that says the work was not qualified because standard procedures were used to resolve the problem, what part of that, of your decision, do you think they might be ignoring?
Well, they did not give sufficient, in my view, sufficient effect to reasonably predictable. I think that if there's reasonable predictability, the fact that only routine engineering is utilized in reaching that conclusion, I do not think disqualifies the scientific research.
Yeah, continue.
Do you believe that the entire question of eligibility not only is based upon developing techniques that didn't exist, but perhaps choosing from existing techniques? Could it be that there are 3 or 4 or more techniques that are known, but without experimenting with them and seeing how they affect each other, would you say that that would constitute a legitimate uncertainty?
Oh, I should think so, yes. Why not? You don't know the result that you may use routine engineering procedures, but you don't really know what result you're going to get.
Okay, continue.
One of the points that we have made is that the definition for routine engineering must be supported by what would be akin to the proverbial three-legged stool. You have techniques, procedures, and data. And without these three supporting legs, the stool would topple.
Yes, because the third leg is an integral part of the stool.
All right, so I guess we want to just step back for a moment, and whether or not we're talking about getting money from the government or dealing with issues with CRA, which invariably will affect any fast-growing company at a certain point in time, I'd like to turn it over to the panel to discuss how you resolve issues. Perhaps, Brian, I'd have you kick it off with the various methods that you use when you typically resolve matters, first with the CRA and then with the Department of Justice, and possibly what an expected outcome would be, when is good to go to court and when is not.
Well, I find, I think I mentioned before, I find with the CRA, you really have to have documentary evidence to support your position. At that stage, they're I won't say in all situations, but in most situations, they're not particularly interested in fancy legal arguments. So I can be pejorative for a second. They just want to see the facts. And I think that you have the most success at the CRA level if you can show them that their understanding of the facts was not correct. That you can show them factually that they've missed something or there's something else they should be looking at. If what you're saying to them is that you agree with their facts, you just disagree with the law, I find it very hard to convince CRA to back off. Then when you move it up to the Justice Department, there's a lot more play in there. First of all, they are lawyers. They appreciate the legal arguments, and they're much more likely to give you a hearing on the law as opposed to simply the facts. So yes, you still need the documentary evidence, but you have an opportunity to convince them that they're wrong on the law, or that there's at least some doubt on the law. A lot of the times you're trying to saw it off, so you don't have to hit it out of the park. You simply have to show that your argument has some merits to it. Going to court, when to go to court, I mean, that's it's always a very difficult judgment. A lot of it is how much is involved, what is the cost going to be to go to court, what's the likelihood of success. Sometimes you have to, with your client, come to some kind of, I guess, mini guess as to what the likely outcome is. It's never very. I had a principal who said, "There's no case so bad that you can't win it, and no case so good that you can't lose it." So you have to try to evaluate as best you can what you think your chances of success are before you press on to court. I don't know if that's a response to your question. If you have anything to follow up on.
I would say that I quite agree. I would further say that clarity is also important. In the event that you do go to court with a matter, whether it be scientific research or any other subject, making your position clearly understood, I think, is critical. If a judge doesn't understand, he's no different than an auditor from CRA. The easy thing to do is to say no if they don't understand. Perhaps, Michael, I would ask you for your view of how to state your case in a way that clarity is achieved. How do you identify the key matter, and what are you asking the court to do, and how do you do it?
Thanks, Todd. Well, you have to be good at what your trade is. That's how you sort of learn what a good case is and what isn't. Presentation is very important, both in tax court and in civil litigation. It's clear that judges do not want to hear 5 different key things. They want to hear 3. You have to give them your best 3 up front, make it a fair and reasonable and understandable argument. The other arguments waste time. So obviously sometimes you can have 4, but you don't want to overload a judge on facts that aren't going to be relevant in his or her decision making. So that's the same thing here as Brian has just said. Well, in my opinion, it's preparation in any event. And if you're dealing with scientific information, you've got your experts to talk about that. But in other forms of litigation, well, you have experts as well, but usually it's the lawyer herself or himself.
Now, Brian, I recall that as a chairman of Tax Law for Lawyers, you had recited an account of Chief Justice Bowman doing a presentation at the Ontario Bar Association program and stating about your closing remarks. Maybe you could recite that.
Well, yeah, I can't remember the exact words, but I'll give you 2 things here. He was talking about cross-examination, and he said it has to be swift, bloody, and deadly. And if it's not all those, it's not worth doing. I remember a particular case where my client admitted to me just shortly before trial that there was a certain weakness in the case. And he said, well, what happened if the Crown asked him that question? I said, well, you've got to answer it honestly. If you're not honest, you've lost all credibility. Well, the Crown lawyer was one of those people that seemed to hammer every question home and really didn't get to the meat of the matter. And so about 2.5 hours into her cross-examination, she got to the question. Well, you can imagine by that point, the judge had lost a lot of his interest, and the question had no real impact whatsoever. Had she set it up and asked that in the first 10 or 15 minutes of the cross-examination, it probably would have been devastating. So that's an example. Don't waste a lot of time on going after peripheral matters. Figure out, at least on a cross-examination, where the heart is, and go grab your dagger and go for it. Mr. Justice Topinka had a comment I've always remembered, dealing more with oral advocacy. The three B's of oral advocacy: be brief, be concise, and be gone. So make your point and don't belabor it. Make it and get on with it.
Yeah, as far as cross-examination, we were just chatting before the program, and there was a case I had argued where I was asking for an individual to be accepted by the court as an expert. And this individual had displayed an attitude that I was interpreting as being one of somewhat of an elitist viewpoint. And I took a chance because I kind of broke a cardinal rule on asking a question that I didn't know what the answer was. But I thought I did, and I was right. I asked him, "Have you ever been wrong?" And he said, "No." And of course, he was not accepted as the court through order and being accepted because Crown Counsel had opposed my request to the court to have him accepted as an expert witness. And but anyway, to that end, we would like to make a point as a group, and that is, and I'd like to turn this, I'll turn it into a question. Is CRA always right? I'll turn that over to my expert panel.
Well, I think the obvious answer is no. They're quite obviously not always right. But you can't be so dismissive of them as to think there isn't some merit to their position. I think when I'm trying to prepare for a case, I always take into account what their position is and how I can meet that position. I guess it's a question of never underestimating your opponent. You don't want to overestimate them. You don't want to become so scared that you're not prepared to do certain things, but at the same time, don't assume that they can't prove things or they don't know things. That'll haunt you. So it's a proper balance of respecting them without giving them too much respect.
Yeah, I think that the reason I presented the question the way that I did is because oftentimes the pronouncements of the CRA is interpreted as fact by taxpayers. We've heard companies say, accountants, lawyers, we've heard people in business and industry say, oh, it's not correct because CRA said so. And I agree with Brian. There are some, oftentimes they are right. But like anyone else, they can be wrong, just like you or I or anyone else can be. And the fact is CRA does not make the law, they interpret it. And they utilize their understanding of the law. And it isn't always that the courts agree with them. And there's instances where legislation has later been changed because of court cases that have, in some cases, had an outcome that in the mind of CRA wasn't right. So they can go from not being right to right as well. So respect, yes.
You like quoting Chief Justice Bowman. Well, remember him once saying before a panel at the Canadian Tax Foundation, commenting on the case, does that make any common sense at all? So if the position of either position, either your position or the position of the Crown does not make any common sense, then I think the answer is to stand back and look at it again. If it's the Crown that's taking a position that makes no sense, then you know you've got a very good chance of success. If you can stand back and look at your own position and say, well, it has no common sense to it, I think you should realize you've got an uphill battle.